Hello everyone and welcome back to another live stream with me, Grizzly. This is Grizzly True Crime, and today we're going to be watching the final pre-trial hearing of Brian, I can't help saying Brian freaking Walshe. Every time I say it now I'm just like, Brian freaking Walshe. It's been a while that we've been waiting for this trial to happen. I have a full case playlist for you that we've done lots of deep dives on. We were ready 2 years ago, okay? We are so ready for this trial now. So today's the final pre-trial hearing. Then tomorrow, November 18th of 2025, jury selection starts, and it's anticipated that December 1st of 2025 will be the opening statements. I'm going to be covering this trial. I hope that you'll watch it with me. I'm pretty sure there's plenty of snark to go around here, meaning also, my word, his Google searches, I can't wait until they show all of that at the trial as well. It's one of those. Okay, so what we're going to do right now is actually a quick case recap for those of you who maybe missed all the deep dives on the playlist. Maybe you want to revisit that later. Let's do a little bit of like a quick overview, a mini trial prep, shall we? So let's bring up my presentation that I have here for you. Okay, and I'm going to quickly take that away. All right. So welcome everyone. Please like and share so others know that we are live right now, and then they can join us, okay? So Anna Walshe, her maiden name was Knip, was a 39-year-old Serbian-American real estate executive and mother of 3, originally from Belgrade, Serbia. She moved to the United States in 2005 and worked in hospitality before becoming a regional general manager for Tishman Speyer, a real estate firm in Washington, D.C. Anna was last seen alive on December 31st of 2022. Technically, it's actually January 1st of 2023, based on a friend that had been over for New Year's Eve dinner. So I think they stayed just beyond midnight. And that's the last person that saw Anna alive, obviously, besides the accused husband, Brian Walshe. So her husband, Brian Walshe, has been charged with her murder and will be on trial in Dedham, Norfolk County, Massachusetts soon. And as I told you, when our opening statements, they said hopefully. They do say hopefully. They're being cautious with it. They can't say it's exactly on December 1st, but I hope it will be. Whenever it is, whether it's the 1st, 2nd, 3rd, 4th, I don't care. We'll be ready, okay? We're going to be watching this together. The trial's set to last for 2 to 3 weeks. I mean, Anna, wow, she was really beautiful, hey? My goodness, and mother of 3, her poor sons. So Brian and Anna met in 2008 while she was working at a hotel in Boston where Brian was a guest. In 2014, Anna had actually filed a police report saying that her boyfriend, who was living in Massachusetts, had threatened to kill her and a friend. She was dating Brian Walshe at the time. So even though she didn't name him in the police report, she did say that, you know, it was her boyfriend at the time, and that was Brian Walshe. So the case was closed as Anna did not pursue it further. Approximately 1 year later, they were engaged, and on December 1st of 2015, they were married. Okay. So there's some pictures of them as well there. They had 3 young sons, and at the time that Anna was murdered, they were 2, 4, and 6, like 3 really young, precious sons. I feel so sorry for them because now their mom is presumed to be murdered and their dad, he's in jail awaiting a murder trial, and he faces life without parole if convicted. So they've been in the care of DCF. So they lived in Cohasset, Massachusetts, a affluent suburb in the south of Boston, but their marriage was reportedly strained, with Anna commuting to DC for work and Brian staying home with the children. So I don't think he was working at the time. He was also on, you know, he was at home, but he had been charged with art fraud. We'll get into that. Brian has a notable family background. His father, Dr. Thomas Walshe, was a prominent neurologist who disinherited Brian, damn, in 2018, citing his son's lack of common sense and propriety. Whoa, the dad was like, yeah, I'm disowning your ass. Okay, so Brian unsuccessfully sued over the estate, and on April 1st of 2021, Brian pleaded guilty in federal court to defrauding art buyers involving forged Warhol Shadows paintings sold for over $80,000. Yeah, committed art fraud. Now this picture, trigger warning, of course I should have said that before I showed it. You could just see Anna with an injury on her eye. She said on May 1st of 2018 that this was from a fall from work. So she just posted this, and her post actually said mild concussion, bruised hip and cut, #vulnerability. And then her friends were like, wait, what is going on here? And she's like, oh, no, I fell at work. But do worry about that. This case definitely with a previous police report, him threatening to kill her, allegedly him threatening to kill Anna and a friend. Yeah, I'm thinking there's a lot of red flags for domestic violence here, right? Now, Anna was last seen alive January 1st of 2023 at their home in Cohasset. Brian and Anna had a friend over for dinner for New Year's Eve, and when they left, she was never seen again. Brian initially told police that Anna left early that morning to catch a flight to Washington, D.C. for a work emergency, and claiming that she took a rideshare to Logan Airport. However, the investigations revealed that there was no evidence of her booking a flight, taking a rideshare, or appearing on any surveillance, let alone airport surveillance. Her phone last pinged around 3:14 a.m. that day. Prosecutors allege that Brian killed Anna in the basement of their home sometime after a New Year's Eve dinner with a family friend, and then dismembered her body using a hacksaw and disposed of the remains in trash bags at various locations. Now, I just quickly want to show you a clip here because they actually interviewed the friend who was there for that New Year's Eve celebration, so the last person to see Anna. And then they left, and I mean, it seems like based on the timeline, shortly after the friend left, she was murdered. Okay, here we go.
WBZ exclusive. Just minutes ago, WBZ's Julie McDonald spoke with a man who celebrated New Year's Eve with the Walshes. He was one of the last people to see Anna Walsh before she disappeared. Julie joins us live in Boston now. Julie, what is this friend telling you tonight?
Well, Lisa, I've spoken with so many of Anna's friends since we first learned of her disappearance from police late last week. These are families along the South Shore.
Let me just boost it a little bit for us. Hold on one second. Just want to make sure that you can hear it nice and loudly. Okay, here we go.
Friends of hers in D.C., even former employees here in Boston in the hotel industry. It's been a roller coaster, emotional week for these people, desperate for information and really holding on to hope that she would return home safely this morning. Devastating news, those chilling details presented in court, and they all learned at the same time that we did. But late this afternoon, just now, I sat down to exclusively speak with one of Anna Walsh's very best friends. Now, Jem Mutlu is her former boss before she took this job in Washington, D.C., but he's so much more than that. This is a friend who was at the Walsh home on Saturday night and one of the very last people to see this Cohasset mother before she went missing. He's been in very frequent communication with investigators, meeting with state police, calling them multiple times since to provide any possible details that he can to help them as they search for his friend. But he described for me how everything seemed as it always was Saturday night celebrating the new year together.
Brian had cooked an elaborate meal for us, and we hugged and celebrated and toasted and just what you do over New Year's, and there was a lot of looking forward to the new year. Like there was no indication of anything other than celebrating the new year, like problems on hold, whatever life's problems were. And life always gives us matters and problems and things to deal with, right? That just always is. But the fact that they hadn't, they had been living in separate homes, she was commuting back and forth, she wasn't seeing the children as often as she would have liked. I mean, she loved everybody. She definitely loved her children dearly. And so it was festive. She was texting with friends, and, she was sitting next to me at the bar stool and at their kitchen. There was absolutely no indication that any modicum of a tragedy of disappearance or anything else could have happened that night.
Shame.
Now, this dear family friend, Jem, he actually met Anna years ago through Brian. He was first friends and colleagues with Brian through a leadership course years ago, then met Anna and has closely befriended this couple over the years. Even that being said, his closeness and his love for this family, he admits that there were times during this week that he began to feel that this timeline didn't add up, and he sadly suspected foul play.
Shame, as everybody did at the time then as well, because Brian didn't report Anna missing. He just told police after a co-worker reported her missing on January 4th. Oh yeah, no, she's on a work trip. So they're like, okay, let's check surveillance. Yeah, no, she didn't leave the house, cell phone last pinged at home. Yeah, so Anna was reported missing on January 4th of 2023 by her employer and a family friend after she failed to show up for work. He was arrested on January 8th of 2023 for misleading investigators. He claimed that he went to Whole Foods and CVS, but surveillance showed otherwise. On January 18th of 2023, he was charged with first-degree murder, misleading a police investigation, and improper conveyance of a human body. Anna's body has never been recovered, making this a no-body murder case, which is rare, but prosecutable. As we know, we just saw Matthew Paul's trial. One can prosecute a case like this. That was not a no-body case, but that was a circumstantial evidence case. In this case, it's a case where they have not found the victim's remains. Shame. So now, his Google searches on January 1st, like that's that very day, you know, when she's last seen. Okay. From his son's iPad, which they linked obviously to Brian Walshe, included queries like, how long before a body starts to smell? How to stop a body from decomposing? 10 ways to dispose of a dead body if you really need to. Hacksaw, best tool to dismember. And can you be charged with murder without a body? Additional searches on January 2nd and 3rd covered what happens when you put body parts in ammonia. And is it better to throw crime scene clothes away or wash them? You see what I mean? Like, oh my goodness, get the digital forensics expert. Yes, put him on the stand. We want to hear everything you found. If that's what we already know, right? So physical evidence includes blood stains and a bloody knife were found in the basement. Surveillance footage showed Brian Walshe purchasing $450 worth of cleaning supplies, including mops, tarps, and tape at a Home Depot on January 2nd of 2023, using cash and wearing a surgical mask. Yeah, okay. He didn't go to Walmart though. Wrong store again, eh? He was also seen disposing of trash bags at multiple dumpsters, including in Swampscott and Abington. Items recovered included a hacksaw with human tissue, Anna's Prada purse, necklace, COVID-19 vaccination card, and clothing matching what she wore on New Year's Eve. So they found that. DNA from bags matched Anna and her children. Okay. Then Anna's phone, watch, and passport were not found with her. Brian sold Anna's Mercedes SUV shortly after her disappearance and attempted to sell fake art again while under investigation. A ransom note sent to Brian's father-in-law in Serbia demanded $300,000, but it was deemed a hoax, possibly orchestrated by Brian. And what we know about him so far, yeah, that's sounds about right. He would do such a thing, right? And yeah, I can't believe he continued to try to sell fake art. Okay. Now, he's facing first-degree murder charges, mandatory life without parole if convicted. Oh, he might get LWOPed. Okay, I think it's very likely. Misleading a police investigation and improper conveyance of a human body. What's the motive? Speculated to be because Anna wanted a divorce and had discovered his art fraud in the months before that, and that they were also in debt. So I wonder if there was life insurance, you know? He has pleaded not guilty, and his defense argues lack of direct evidence, potential tampering, and that Anna's disappearance could be voluntary or accidental. Prosecutors, led by Norfolk County DA Michael Morrissey, emphasized the circumstantial evidence, including the searches and the DNA. Yeah, I think they've got more than enough, right? Brian remains in custody without bail. The couple's 3 children are in state custody with Anna's mother, Milanka, seeking guardianship from Serbia but facing visa issues. On September 11th of 2025, Brian was stabbed, or shanked as they would say, at the Norfolk County Sheriff's Correctional Center. Following this incident, he was sent to Bridgewater. He was sent to Bridgewater. Okay, the court feeds are starting. The courtroom is empty. I'm going to switch over to that as soon as we're done with this, which we almost are. Okay, following this incident, he was sent to Bridgewater State Hospital in Bridgewater, Massachusetts for his mental competency evaluation. So he was all shaken up by the traumatic experience of being shanked in jail, and off he went for his mental competency evaluation. Initially ordered for 20 days, but then it ended up being extended and he was there for 40 days. His defense said in a recent hearing they're not so sure how he's going to be coping mentally now that he's back in the jail, because he's back there now. So that's like always, you know, that's what I mean. I hope there's no more delays with the start of this trial. Also, somebody said in chat, Zen Jen said, I wonder if the uncertainty around trial date is due to plea negotiations. I mean, it could be, right? It could be. So we shall see, right? But yeah, so he's back in the jail, and jury selection starts November 18th of 2025 with opening statements anticipated around December 1st of 2025. Okay, was that my last slide? Is that it? Is that what we have? Yeah, that's what we have. Okay, so now let's bring up, let me just quickly see what's going on here in the courtroom. Okay, wait, let's just refresh this quickly. Yeah, they're definitely going to be showing him soon, aren't they? Okay, wait for it. I'll bring it up. Let's go like this.
Good morning, Your Honor. In the matter of Commonwealth versus Brian Walsh, criminal indictment 2023-0091. The matter is scheduled for a final pretrial conference this day. Defendants represented by attorney Larry Tipton and Kelly Porges, and the Commonwealth by ADAs Greg Connor, Ann Yaz, and Tracy Cusick. Counsel, starting with the Commonwealth, kindly identify yourselves for the court and the record.
Good morning, Your Honor. Gregory Connor for the Commonwealth. With me as Assistant District Attorneys Ann Yaz and Tracy Cusick.
Good morning.
Good morning.
Good morning, Your Honor. Kelly Porges on behalf of Mr. Brian Walsh.
Good morning.
Good morning, Your Honor. Larry Tipton for Mr. Walsh.
All right. Good morning to everyone. We bring the defendant in.
Southern Cali says, I already wrote it in pen, G. You're feeling confident about that date, are you? Well, let's hope it is. Yeah, bring the defendant in. Let's all look at him. He is, of course, innocent until proven guilty in a court of law. I think in the court of public opinion, what a dumbass. You're going down, bro. Those Google searches, the cleaning products you bought, the fact that you don't know there's surveillance, that the police can't see that you're literally lying to them about where you were. Come on. Let alone the DNA evidence, the bloody knife in the basement, which I'm sure they tested. We'll hear about that at the trial. So welcome everyone to Brian Walsh's final pre-trial hearing. Thank you for being here with me. Please like and share so others can find us.
With the court's permission, would you feel comfortable if Mr. Walsh remained uncuffed, at least his hands during the proceedings, so we can take notes?
Check that with the court officers. I defer to them. I don't have any, as you probably know.
Okay.
I don't have any objection to that.
Okay, I'll check with them. Thank you.
I'll check with them when they come back in with them.
Okay, thank you.
I certainly don't intend to have his hands cuffed during the trial, so.
Of course not.
We would like that though, please. Can we put in a request? No pens for you. Hands cuffed. Have a, what do they call those again? Shock belt.
I bought one this weekend.
There's the word I was looking for, a stun cuff.
Thank you, Madam Clerk.
Will he have a stun cuff on? I think so. Stefan says, you can write notes in handcuffs, buddy. There he is. Brian Walsh, 50 years old. He's got handcuffs on right now, and he's got his little folder.
The motions that came in over the weekend.
He's really dressed up all the time, hey? I just mean like he's being held in jail with no bail, apparently. But look at him. His defense helps him look the best, hey?
All set? Thank you. For the record, the handcuffs have been removed from the defendant so that he can fully participate in today's hearing. So the purpose of today really is to go through the motions and Limine to see where I can give you some rulings and some expected rulings. I always say expected rulings because I like to think of a trial as a living, breathing thing that evolves, not something that is pre-planned. So these are my best guesses. Sometimes I'm making actually affirmative rulings because I know enough that I don't think anything will change, but if it does change, I'll let you know. So I'll just start. I'm going to go through those motions that we went through a couple of weeks ago in the same order as they're listed. Instead of, I'll start first with the pretrial motions. And what we have left over there are the following. And before I move to the motions and Limine, I'll give you an option to check in on others that you think that I might have missed. So, first motion that I think...
the judge, I think it was on Friday, denied his motion to change the venue. So that's already been dealt with.
Needs tending to is paper number 184, which is the Commonwealth's motion for use of streaming platform to prevent juror exposure to extraneous matter. With an affidavit in support, the defendant did not object. The request is to use the standard Zoom format. The court intends to do that. And so that motion is allowed. There will be no other streaming platform used in this trial other than Zoom. Any questions about that?
Your Honor, just briefly, there's the standard Zoom platform in which remote users are able to unmute themselves, and then there's the other version where they can't. I don't know what the name of that is. Are we using that version?
We're using the version that they can't unmute themselves.
Thank you, Your Honor.
Okay, so no law and crime court TV cameras in the courtroom. Zoom.
Paper number 185 is the Commonwealth's motion for an order to prevent juror exposure. This is a sort of a called the stay away, no contact order, so to speak. I don't know that we're going to need it. It's hard for me to judge what is going to be the appetite for either demonstrators in this case. I don't see anybody outside yet, and I'm hoping it stays that way, frankly.
Your Honor, I think the parties are all also hoping it stays that way. In the event that there's any information suggesting that there might be any sort of demonstration outside, how could we communicate that best to the court, information that we might...
Through the clerk. The best point of communication always is Madam Clerk.
Thank you, Your Honor.
So if things change outside, and I have a skewed version of it because I sit out on the back, so I don't see what's going on out on the front of the building, but if it changes, you let us know, and I won't hesitate to order that, because of premier importance to me is keeping that jury that we pick in their fair and impartial state throughout the entire term.
Quick pause, sorry there. Mandy said, does that mean we can't watch? No, I think that means we can watch, but it's going to be via Zoom. The very first trial that I ever streamed was Letitia Starks, and that was done on Zoom. It just makes defluffing a little harder, so we might have to do morning and afternoon sessions, but don't worry, that's my problem, not yours. We will be watching it together, okay?
The trial. So the supplemental questionnaire, I'll get that to you today. I did add in, as requested by the defense, I changed those 3 questions to be 3 separate questions. I added in the additional question that the defense asked. I think we, at the side of the bench on Friday, the Commonwealth indicated to me that it didn't have any additional edits to that. And I did see some motions came in this morning. I can't say that I spent a lot of time looking at any of them, but I did see that there was a revised witness list, which the Commonwealth eliminated witnesses that it no longer intends to call, and added a few witnesses. Which reminded me, so I'm going to, that witness list as abbreviated, we talked about cutting out the custodian of the records and adding in the defense witnesses to the appropriate subheading. And not on Friday, but previously, I think I said to you that, said to the defense to take a look at where I put them to make sure that I put them in the right bucket, so to speak. Have you had a chance to do that? And are you content with where I put them?
I know I looked at it, Judge. I don't remember, but I think that it was fine. And I'll take a look at it before I leave today, but I think it's fine.
Okay. So what I'm probably going to do is take the new witness list from the Commonwealth and then add those people back into the same spots that I put them on the prior version, rather than try to figure out who the Commonwealth took off. But sometime this afternoon, you're going to get the questionnaire and you'll get the attachment that I intend to, and just take a look at it for the final. We can always make changes in the morning. And while I'm on the topic of questionnaire, I think I told you, I think it's the most efficient way to get the information to you, and the least logistically challenging way is the way I've done it really in almost every case that I'm using a questionnaire now, which is those questions are designed in a particular way such that a yes response requires further follow-up. And so when that person comes in, and I'm pretty sure now that we're going to be impaneling in this courtroom. I didn't think that the last time I talked to you, but based on what's happening in the other courtrooms, I can't get a clear courtroom somewhere else. So we are going to impanel in this courtroom. We'll be using the whisper technology for strikes. When the person comes in and is seated, I will follow up on any missing information on the statutory questionnaire and any yes answers to the questionnaire. And then I have a few more follow-up questions if the person's still standing and is still a viable potential juror. One of the questions that I think I'm going to ask in that individual voir dire is to tell the prospective jurors that during the course of the trial, they need to agree not to be on any social media, and they need to agree not to watch the news in any medium. That's a big ask, but I think it's a necessary ask given the level of publicity, media coverage in the case. Anyone have an objection to that?
No objection. Objection, Judge? Could I just ask a question, Judge? I looked at my notes from our last discussion. I read my notes to say you weren't going to give us copies of the questionnaire.
That's right. So how do I do that?
Yes.
So you'll have a blank questionnaire, of course. Mm-hmm. And so what I do is I have the person come in, I tell them in the empanelment script, you fill that out, give us your honest answers to the questions, you fold it together, and you keep that document in your possession. Don't show it to anyone until you hand it to me. So they will come up to the side of the bench, they will hand me the questionnaire. Mm-hmm. I will then recite. Juror number 40 answered yes to questions blank, 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 and blank. So you'll know what questions they answered yes to. And occasionally people don't answer, and they'll put a question mark, or they'll write something. And if that happens, I read literally what they wrote and where they wrote it. And if you at any point want to look at the questionnaire, that's fine with me too. I just want to prevent the both the time and the paper that's involved. Jury selection is so paper intensive anyway, the last thing you need is more questionnaires. But if you want to look at the questionnaire at any point, that's fine. And then at some point, the very last question, as you know, on the questionnaire says, whether this would disclose anything that would be personal to you. I presume that some number of jurors are going to answer yes to that question. At some point, typically at 1 o'clock, I will have the required hearing under URIP to seal those questionnaires. And you have to give, under the rule, you have to have a hearing. So it'll take about 2 minutes, but we will have that hearing at some point during the early stages of the trial.
Thank you, Jimmy.
The Commonwealth filed a preliminary request for jury instructions. I just want to bring that to the defense's attention with regard to the elements of all of the crimes, so that if there's any objection to that, the murder one is really the SJC's, and I don't know that you're going to be dabbling with that, but with regard to the others, just take a look at those so that we're all on the same page with regard to the elements that are attenuate to the other crimes, all right?
We have, Judge, and at the appropriate time, we do have an objection to some of their requests, but we'll deal with that when the court wants to.
Okay. I think we're a little before that point, but I'll be happy to hear you whenever you want to bring it to my attention. We've dealt with on Friday the motion for change of venue, and we also, I guess implicitly, if not explicitly, have addressed the defendant's motion for leave to conduct attorney-conducted voir dire to the extent that the defense is asking for panel. I'm not going to exercise my discretion. I'm going to do the traditional individual voir dire. And of course, you play a big role in that. That's all I have for non-motion in limine pretrial motions that I think that I could give you some rulings on. Before I move to the motions in limine, is there any other non-motion in limine pretrial ruling that you're looking for?
Your Honor, the Commonwealth did file a motion for reciprocal discovery.
Okay.
The defense did provide us with a notice of intent to call Dr. Banerjee and an outline of Dr. Banerjee's opinion if she testifies. The Commonwealth is requesting the proposed potential testimony of Dr. Lakin and Joel Scoletti of Safos Corporation, who are identified as potential experts by the defendant, and also Dr. Dan Feria and Steve Verino of MVP Forensics, also identified as potential defense experts. And also Tim Creamer has been identified as an investigator. Commonwealth is requesting any statements that Mr. Creamer has obtained, and also the substance of any testimony he may offer.
Good point to Paul. Look at the judge's face. Gusta, thank you for upgrading your membership to Grizzly Super Supporter. I really appreciate that.
We have no opinion, we have no reports, we have no statements. I will, though, provide them with a summary of what I anticipate the other experts would testify to. I'll do that.
All right, when can you get that to them?
Pardon?
When can you get that to them?
Wednesday?
Seems reasonable. Any other non-motion and limine motions?
Zooming in on the defendant here. Indeed, this is in Massachusetts, yes.
All right. So I'll move to the motions in limine, and I'm going to take them in order, I think, with the exception of maybe one of them. When we get to it, I may pull that to the end. So paper number 187 is the Commonwealth's motion to limine number 1. It's to provide the jury with a means to review electronic exhibits during deliberations, and the defendant did not object to that as of at least 10:31. Same position today, right?
Yes.
Look at
It's
him.
allowed. The Commonwealth needs.
They're going to look at my Google searches? Yeah, they are. They're going to look at everything you did. $450 worth of cleaning supplies. Wow. Googling, what should I do with my crime scene clothes? You know, should I throw them away? Should I wash them? What should I do after committing a crime? You know, how long does it take for a body to start to smell? Yeah, they're going to see all of that, Brian Walsh.
To ensure that the laptop that is in the jury deliberation room is contains no other information other than the information that's necessary, the software that's necessary for the jury to review the material evidence.
We will do that, Your Honor. There is a special laptop that will be used for that purpose, and it will be provided to the defense to inspect it.
All right, and that was the second part of my order, which is the defense is ordered to review that laptop before it goes in to make sure that we don't have any glitches. Paper number 188 is Commonwealth's motion in limine number 2. It's to notice of any visual aids defense intends to display during opening statements. The defendant objected to that. Is the defendant still objecting to that?
It is. We are.
The motion is allowed.
It is.
As to opening statements, I want to see any chalks that you're intending to use. It's for your own good. Because if I determine that there's something on that chalk that is inadmissible, you are not going to be able to use it because you're not going to be able to turn it around. Go right ahead and state your objection on the record.
Well, Judge, I would just like to explain something. I object to it for a very simple reason. I've been doing this for 20 years. I've never had an objection in either my openings or my closings when I've used visual aids. Secondly, I only include visual aids that I know are going to be exhibits that are admitted. If I have any question about anything that I would use visually for the jurors, I approach the DAs, I approach the court, make sure that we're all in agreement that's an exhibit. I don't use
Then why are you objecting to it then?
Because it gives, if I give it to the Commonwealth before I make my opening, they have a roadmap, they have a preview of what we're going to say.
Everyone's supposed to be getting a preview of the evidence.
Not of my opening and not of my thoughts.
All right, I'm not going to engage in a discussion about this. Any chalks that you intend to use that are not agreed to exhibits need to be shown to the court and to opposing counsel.
Okay, Judge, just so I understand.
And it can be the morning of, but it's going to be before you're holding something up in front of 16 jurors that we spend 2 weeks picking a jury for. No, not happening.
And I don't want it to happen, but let me just clarify something. I understand the court's ruling so far. Chalks, but not what we know to be exhibits.
If you have, and I know you have, agreed to exhibits, then you don't need to address that. Those are agreed to. You know it's agreed to. You can show those.
Fine.
If you have chalks, different thing, that you want to put in front of the jury, I am not letting you stand up before the jury without me seeing it first, and the Commonwealth see it first. It can be the morning of, but I do not want you showing a chalk to our impaneled jurors without me seeing it first.
I understand, Judge.
You tell him, Judge. Sorry, Mr. Defense Attorney. I like this judge, though. Damn. We like strong boundary setters, hey? And snarky judges. I think she's a grizzly already. We've only just seen her, well, we've seen her in other hearings, but you know what I mean, together, now. Yeah, I like that. Okay, let's keep going.
All right. Paper number 189 is Commonwealth's number 3. It's for notice of any third-party culprit evidence. The defense has indicated that he understands what the rules are and you're going to abide by them. There's no ruling necessary. Paper number 190 is Commonwealth's number 4, notice of any proposed reputation testimony. It also relates to, I have them in my notes, see paper number 193 below. 193 refers to any bad character, bad reputation of the victim or any of the witnesses, and alleged prior bad acts of the victim or any witnesses. The defense has objected to that, arguing that he intends to bring in evidence of general reputation evidence. Is that right?
Your Honor, at this point, we don't have any notice of specific reputation evidence that we'd either offer through cross-examination or in any case in chief for us.
Okay.
The concern I do have is the Commonwealth has indicated they expect to introduce evidence, quote unquote, that Anna Walsh was a loving mother who would never have abandoned her children and was a dedicated employee. So I'm sure the government is aware of the restrictions on how this evidence will come in, but that may or may not be relevant, and so I'd ask the court to revisit this before they seek to put this information in.
All right, Commonwealth.
Thank you, Your Honor. Your Honor, the Commonwealth does plan to call witnesses who will testify as to their observations of the victim at her employment. Her employer will testify, as well as her former employer, who was the New Year's Eve guest, will testify as to her.
Is it Metlu or Mutlu, or how do you pronounce his last name?
Mutlu, Your Honor.
Mutlu?
Mutlu.
Okay, I'll try to remember that.
Thank you, Your Honor.
The Commonwealth will be introducing evidence to those persons regarding the victim's work ethic and
Observations or interactions with the children?
yes, Your Honor, observations and interactions with the children.
All right. I'm not going to give you any firm rulings on it. You raised your objections at the time. I will tell you generally that I probably will allow observations of her, not to an excessive amount, whatever that in my mind becomes excessive, but general observations as to the victim's interactions with her children is permissible.
Your Honor, I would just add that the law is clear on this. They can't have specific acts, so an observation would be a witness giving their opinion or testimony on a specific act. And so that's not admissible. What they're allowed
You're right, opinion or testimony.
So observations, how are observations of her with her children relevant, which I suspect may or may not be relevant once we start? And it can't just be a limited number of people. So one person from her work saying that she had a good work ethic, the case law says you cannot do that. It has to be the general reputation of a community. And so I guess we will just raise the objections at the time. I just wanted to put the court on notice that any of this testimony could just be inflammatory and prejudicial and invoke sympathy of the jury to hear that she was a great mother and a great employee.
All right. I hear your objection, and I encourage you, and I know that you don't need any encouragement to make the real-time objection at the time of the trial, and I'm just trying to give you some basic guideposts of what my present thinking is with regard to that evidentiary issue. Anyone want anything more on that particular motion?
No, thank you. Not at this time, Your Honor.
Commonwealth's number 191, motion in limine number 5, is to allow in-court identification the defense asked for, and the Commonwealth has now given, I see this morning, a list of the witnesses who will so identify. Any issue that I need to be aware of with regard to that?
No, Your Honor.
All right. So that motion is allowed without objection, and the Commonwealth has satisfied the defense's request to provide names as of this date. Number 6 of the Commonwealth's motion in limine is to preclude reference to or introduction of irrelevant conduct of testifying and non-testifying police officers and agencies. The defendant objects, and I'm happy to hear further argument on this if you wish, but the defense's objection to me was, I wrote in my notes, it depends on what the Commonwealth does in its case in chief. And so you've alerted me to the issue, and we'll take it as we go along. With regard to a preemptive ruling in that regard, nor do I think that it would be part of your opening statement, because the opening statement is supposed to be a preview of what the evidence in the case will be. And so the defendant may not open on this without raising it with the court. It wouldn't be expected testimony at this point based on your opposition, or seek to introduce that evidence without readdressing it with the court affirmatively at the time that you're going to do it. All right? Commonwealth's number 7 is paper number 193. I think we just went over that with the other one, so I'm going to bypass that. Paper number 194 to Commonwealth number 8, to admit photos of digital devices rather than the actual devices, and the defendant did not object, and that's current today. That motion is allowed without objection. Let me pause on 195 because I think we're going to have to go through. Let me just say, first of all, Commonwealth number 9 is to admit the defendant's 4 recorded interviews with the police. I saw this morning, but I haven't really had a chance to look at it. The Commonwealth supplemented its legal briefing with regard to statements of Miss Minor and of the minor child. I want to look at that, and I want the defense to have an opportunity to look at that. I looked the case over quickly this morning, but I frankly didn't have much time to deal with it. But I'm going to circle back to that motion because I think we're going to have to go sort of on the micro level and start going statement by statement, which is going to take some time. So I'm going to put that towards the end of this hearing. Paper number 196 is Commonwealth number 10 to admit NCIC missing person form for Anna Walsh. Defendant didn't object, correct?
Correct, Judge.
It's allowed. Paper number 11 of the Commonwealth's motion and Limine to admit photos and a short video of Anna Walsh as she normally appeared. The defendant objected. So I haven't seen the video. Does the Commonwealth have a way to show me the video?
I believe we could email it to you, Your Honor.
I meant like right now.
Your Honor, I have it on my computer. If you can give me a moment, I can walk up to the bench.
Judge, I mean, right now.
Generally, what is the video of?
It's her with her 3 children on a rug in the living room of the home.
And why is it important?
The rug, an identical rug was found in the dumpster outside of the defendant's mother's home.
Your Honor, I can approach, but just what might make it easy is the video is unnecessary. They could do a screenshot of the video which portrays the rug in question. I can approach and I can show you.
Yes.
Hopefully
Sure.
they don't show us the video. Even though we want to see it, I'd just been shame. They put children. They would have to blur out their faces, you know? Look at him taking notes with his little pen. Shame. Okay, they're showing that he did go to his mother's house. He went, where did he go first? He went to buy cleaning supplies. He went to his mother's house, stopping at a whole bunch of dumpsters along the way. And so they say there was a rug. Oh. That they could see in a photo where Anna's with her 3 children at the home with this rug. And
I think it's incredibly inflammatory.
some of the evidence includes a hatchet, a bloody rug, and cleaning supplies. So I wonder if that's the rug in question, right?
And if their sole reason for introducing that is to simply show that that rug was in the home, they can do that with a screenshot.
No objection.
All right. That's the ruling you were going to get, so it's good that you, there is no reason that the video needs to be played. So just take a shot of it, show the shot. Now, with regard to the other photos, you need to use, it's sort of like autopsy photos, in my view. Use the least number you can use to get, I understand that's one picture she's wearing a necklace and one picture she's showing the watch or something else. But use the least number that you can use.
If I may, Your Honor?
Yes.
So I agree with that, and we tried to cull it down. So there's one with a jacket, there's one with a watch.
The black jacket?
Yes. There's one with a watch, and there's one with a necklace. We can probably take away 1 or 2 from what we submitted, because I believe that there's one where she's with Mr. Mutlu wearing the watch, so maybe we can delete that one. So we're talking probably about 4.
Your Honor, the other issue is those photos can also be cropped. And there can be a stipulation that the cropped photograph showing a person wearing the necklace, the coat, is in fact a photograph of Anna Walsh. So they have sent a parade of photographs. I think that there's other ways to serve that purpose, and some might be stipulations. So this.
Well, I'll let you work out whether you have any stipulations, but even if you want it that way, doesn't mean that the Commonwealth wants it that way. And the Commonwealth gets to, hold on one second.
What's going on now?
I'm going to take a break.
Oh my word. What happened? Look at him, he's like, oh my word, what has happened? What did you do, buddy? He wants to know as well. Shame. Okay. Yeah, Southern Canterbury says, the judge says D-fluff. This judge, she's very strict, I like her a lot. Ain't no hollaback girl said, yes, Brian's attorneys are court appointed. Kay's beautiful struggle said, the judge said, less is more. Yes. Shame. If we go to the previous trial we just covered in Wisconsin, the Matthew Paul trial, remember the defense attorney Pablo Galaviz and how much he showed, like how lengthy his cross-examinations were, and then when it was the defense's case, how lengthy that was, and showing that surveillance over and over again of the defendant, now the convicted, in the mailroom. Imagine this judge. She'd be like, no. We love Judge Ramirez, okay? He was presiding over that trial. But this judge, I could just see. Can you imagine if Pablo, he wouldn't survive in this lady's courtroom. I don't think so. Woman of Heart said, he still looks smug. Just turn around, Brian. Yes. Okay, so we can actually, we're 1 minute behind. We can go forward a little bit. Look there.
So,
hey. That helped. Okay,
all
we're
right,
back.
I think I was saying that you may be able to reach a stipulation. I don't know if you can, if you can't. But I think I was just about ready to say that the Commonwealth gets to, within the bounds of the evidentiary bounds, gets to present their case.
I appreciate the analogy to autopsy photos. And so let me go back and see if I can do something that's more palatable to the defense.
That's frankly how I see it. I mean, I understand the significance of the various items that we've just listed to the Commonwealth's case, or I think I understand generally what the significance is to the Commonwealth's case. So I'm inclined to let them have the photos that they're going to need to make those arguments. But they don't need to be inflammatory. And so, yeah, just look through the lens of an autopsy photo.
Thank you, Ron. I appreciate that, and I'll work on it.
All right. Commonwealth's motion number 12 to admit evidence concerning the defendant's federal charges. And the defense is opposing in part. I'll hear from the Commonwealth first on this one.
Your Honor, we have actually attempted to develop a stipulation. The Commonwealth had sent it to the defense, and we haven't heard back as to whether that is something they wanted to stipulate to. We had been working on potentially reaching an agreement as to what information about the federal charges would come in.
All right. Well, to aid you in your discussions, it seems to me, and this actually overlaps with regard to the one of the other motions with regard to the interviews. I understand the importance of the federal case in terms of the Commonwealth's argument with regard to motive, and particularly the timeliness of certain information vis-a-vis the time that the Commonwealth indicates that they believe the defendant did the acts that he's charged with. And the one area that I wanted to probe so that I have the information firmly in my mind, what the evidentiary significance of it is, the weight of it versus the prejudice, is the GPS. So my memory from prior proceedings on this case is that the GPS was not the way that the Commonwealth found out that Brian Walsh was at various places.
That is correct, Your Honor.
All right.
It was not a GPS bracelet.
What was it?
It was a radio frequency bracelet that would go off if he went a certain distance from the home, and he would have allotted amount of time to leave the home to perform errands and drive the children.
Okay. So there's no evidentiary.
That was because of the art fraud that he had committed, right? And he pleaded guilty to in, I think it was April 2021. And they believe Anna was murdered sometime in the early morning hours of January 1st of 2023. So he was being monitored. Okay.
There's nobody coming in and saying, based on how his bracelet, he was at X, Y, and Z. They found that from the phone, right?
That is correct, Your Honor. They found it through the two phones.
So that seems to me to be both in the transcripts and also just to the extent that it's in any of the federal papers as a condition of release, highly prejudicial. And I'm not inclined to let the jury hear about that. It's not relevant to their decision making, and they may, even if I give them a limiting instruction, may make it difficult for them to accept the limiting instruction. It doesn't have any evidentiary value. So anything with regard to both in the interviews, which I know we're tabling for later on, and or in the federal records, that seems to me to have very little evidentiary value to the Commonwealth and has a potential for prejudice to the defense. So that won't be in.
Understanding you've made a ruling, can I make an attempt to change your mind?
Sure.
All right, thank you, Your Honor. I appreciate you giving me this opportunity. So with the defendant's ability to have windows of time that allowed him freedom to leave from the house, it allows the Commonwealth to show the premeditated nature of this crime and that he had windows to clean up after the crime was occurred.
That's a different thing, though. The fact that he has windows of time that he, or certain parameters that he has to be at home, and that comes up in the interview at one point when Attorney Minor makes mention of that. I don't know what we're doing with that yet, but putting that to the side, I don't think that what you just said about windows is the same thing as I'm saying about being on an electronic bracelet.
Okay. Okay.
I think there's different prejudice that attaches to those two things. The fact that he had restrictions, that he was on federal supervised release, and that he had some restrictions is going to be known to the jury. It's integral to the case. But the fact that he's on an electronic monitoring bracelet is a different thing, in my mind.
Thank you, Your Honor. I understand your ruling.
But keep on objecting, as I know you will, but that's sort of the dividing line that I'm drawing in my mind's eye right now. And keep on working on the stipulation.
Yes, Your Honor.
Paper number 199 is Commonwealth's motion in limine number 13. It's to admit the victim's out-of-court statements, evidence of her state of mind, and the defendant's motive to kill her. The defendant is opposing it in part. I'll hear from the Commonwealth first.
Thank you, Your Honor. The Commonwealth would seek to introduce the victim's out-of-court statements to Alyssa Kirby and to Mr. Mutlu and to Mr. Fastow as to her state of mind, which was known to the defendant. Your Honor, certainly the defendant, the evidence will show that the victim had a meeting with a friend, Ms. Kirby, on the 29th of December and told her about the big argument they had had over Christmas.
Give me a timeline because I want to have this in my head. She comes home on Christmas Day.
Yes.
Anna comes home on Christmas Day. She drives because she missed the flight. She spends much of the day driving, and then she gets there on the evening of the 25th.
Yes, Your Honor. I believe it would be around 8 o'clock.
When did she drive back?
She leaves on the 26th of December.
Okay. And she drove back to D.C.
And she drove back to D.C.
And then she returns back to Boston by flight on the 30th.
On the 30th.
All right, that's helpful. All right, go ahead.
Your Honor, on the 29th, when she's still in D.C., the night before her return to Boston, she goes out to dinner with her friend Alyssa Kirby and talks about the big fight that she and the defendant had, and tells Alyssa Kirby...
She'd been home for Christmas.
Yes, over the Christmas break, or the day that she was home. She tells her about that big fight, that she gave the defendant an ultimatum, that she had learned that the reason the children weren't with her was because of the defendant and his attorney, and that she had told him essentially to just resolve the case, even if it meant taking jail as a result. And I know Your Honor has reviewed the paperwork, and it is a little more detailed, some of the statements of the grand jury. Your Honor, I would suggest that this is admissible because certainly it shows the victim's state of mind, that she is prepared to do what she needs to do to take her children down to D.C. to be with her. She had a very highly compensated job, and I know Your Honor is familiar with the circumstances of her moving to D.C. without the defendant and the children. I suggest that that is certainly known to the defendant. He acknowledged and alluded to a big fight over Christmas in the recorded interviews, and indeed said that he had learned after fighting with the victim previously over Christmas, and I believe he said Thanksgiving, that he was not going to fight with her over her alleged need to return to Washington, D.C. for a work emergency. I suggest this is highly probative of the victim's state of mind and the defendant's motive to kill her. It also shows that he is aware of this. He's searching Mr. Fastow's name. He's searching for divorce, and he is conducting those searches in between. I believe the search for Mr. Fastow was on December 25th, and then he's searching for divorce, I believe, on the 27th. His mother then hires the private investigator to investigate Anna's, whether she's behaving appropriately for a married woman. That's on the 28th. Certainly suggested all of this is highly relevant to the victim's state of mind and the defendant's motive to kill her and what happened in that home on the 1st of January. And with Mr. Mutlu, there is some testimony about Anna Walshe had some conversations with him, I believe, on the 28th. And Mr. Mutlu's testimony is a bit indicating in some of his statements that some of it he might have learned from other people, but some of it he did learn from Anna, and certainly the Commonwealth would be very careful to make sure that we were only eliciting what he learned from Anna, not something he had heard from somebody else. And I would suggest that that should all be admitted in this case.
All right. Defense?
Thank you, Judge. Your Honor, the problem I have is the Commonwealth is also cherry-picking parts of these conversations. The dinner that they're speaking about, her and her friend were out until 1:30 in the morning, a night that ended at a karaoke bar. So there was probably copious amounts of alcohol, I would assume.
But that goes to the weight the jury chooses to give to it.
But in the context, I think it's important. The other thing that the Commonwealth didn't seek to introduce is the fact that Alyssa Kirby at the grand jury, at her grand jury testimony, said that they had a very open and honest relationship, and that Anna wanted him to do whatever he had to do so the family could be together. And further, she didn't say that she wanted a divorce or was going to leave him with this ultimatum. Specifically, Anna supposedly said to Alyssa Kirby that she wanted him to choose life because he had been so depressed. And even if he had to go to jail, that will be waiting for you when you get out. Mm-hmm. So I think they're not only cherry-picking what portions of this conversation they want to put in, they're overstating the relevance, especially in light of the case law. When you look at the cases that talk about state of mind, they cite Castano. That was a situation in which the witness had told the defendant in that case that she wanted to end the relationship, that she had rejected his anniversary presents, not only was ending the relationship, but has packed up his bags. And when the police responded to the scene, there was in fact a packed suitcase of the defendant's items at the door. That is not what we have here, let alone to that level. In Martin, the statements that the government was seeking to introduce were basically statements in history of physical abuse, violence, of her trying to take the children from him. That is not what we have here. Half of the conversation to Miss Kirby was how she wanted her family together. They had an open relationship. Couples fight, so to say they had a big fight on a date, she was late for Christmas and they had 3 children. This was not earth-shattering motive to kill information. So I don't think it's fair that these conversations with Alyssa Kirby come in And certainly if the court does see value in those statements as the case develops, then the doctrine of verbal completeness would force the court to allow all those statements to come in, because this was one conversation. So that would be our position with respect to Alyssa Kirby. With respect to Jem, I think there needs to be either a voir dire or some clearing up of what he heard from other witnesses and what he specifically heard from Anna. And again, Mr. Mutlow was with them on New Year's Eve into the 1st of January until about 1:30 in the morning. And he's also described the night as joyous, that they had a happy marriage. The federal case had been going on since 2018. They had been weathering this storm. And so again, if they're seeking to introduce statements, I think that the full conversation would come in to show the context, and we need to figure out what exactly Mr. Mutlow heard directly from Anna.
All right. So let me give you some guideposts. The defense in its opposition cites to Qualls, which is sort of one of the earlier and seminal cases on state of mind evidence. And, but I'm not persuaded by the defense's argument with regard to what Qualls stands for in light of Castano, and in light of which, for the record, Castano's at 478 Mass 75, a 2017 case, and also look at Commonwealth versus Bins, B-I-N-S. That can be found at 465 Mass 348, a 2013 case, at head notes 17 through 22. Under that case law and other cases that I looked at, it is very likely that I'm going to allow Anna Walsh's statements to Alyssa Kirby, the limited purpose of establishing her state of mind as is relevant to the defendant's motive to kill his wife, to the extent that such state of mind evidence includes statements describing his defendant's prior bad acts. His federal case on his statements will be admitted, and with a limiting instruction that it is limited to show the defendant's motive and not to show that he had a bad character or propensity to commit any other criminal offenses. There's a limiting instruction that is posited by the court, the SJC and Benz. It's on the bottom of top of page 419. Take a look at it. That's what I'm likely going to give you. I think that the parties need to do a little bit more work with Jem, and they will, as the Commonwealth gets ready to prep him for his trial testimony, and obviously be in touch with the defense with regard to what that pretrial work reveals with regard to statements that were made directly to him from Anna, as opposed to third-party other evidence that would not be admissible.
Yes, Your Honor.
With respect to William Fasto, there's one notable exclusion or sustained you're going to hear. The statement that she makes to Mr. Fasto about she doesn't know what the defendant would do if he were to find out about the affair is not her state of mind evidence and is not admissible and is prejudicial. So don't go there.
Yes, Your Honor.
And then, of course, with regard to the doctrine of completeness, I think the defense has an argument there. And so I'm inclined to let them bring in the other statements. And you can oppose it if you want, but that's sort of the guidepost that I'm setting right now.
Understood.
All right. Paper number 200 is Commonwealth 14, to allow the admission of text messages conversation as of 11/12. I wrote the defendant had not filed a written objection. I think I invited that at our last hearing, and I'm guessing that you didn't because it's 801D2 stuff, but you let me know if it's otherwise.
So, Your Honor, with respect to the text messages, I think maybe we have some objections to some of the portions of the text messages, but Specifically, and I did talk about this in
Another paper?
defendant's response to Conman motion in Lim 13. The William Fasto text messages, I don't think that any of them are admissible and the jury should not receive them. There is no evidence about state of mind in them. It's text messages about two friends who are having an illicit sexual romantic affair. There's no evidence by the government other than speculation that Mr. Walsh ever even saw these messages.
Is it speculation? I mean, he says in his own words in the interview that somehow her text messages are showing up on my phone or something to that. And I'll go back and listen specifically, but we did cross this issue once before, and that was my recollection. Maybe it's a failed recollection.
No, the statement that you're referring to, there is a conversation between Mr. Walsh and the police where in the same paragraph he says, I'm messenger, not I message, and then there's talk of Facebook messages popping up on its phone. So I don't think it's clear. And even if the court were to infer that iMessages came to his phone, there's no indication that those came to his phone. The text messages with Anna Walsh and Will Fasto ended at about 10:30 on New Year's Eve. Mr. Mutlow was at the home until 1:30. He specifically said, either during an interview or his grand jury, that at no point did he see Mr. Walsh on his phone. He didn't see Mr. Walsh on his wife's phone. He, again, described jovial, happy, up until the time he left at 1:30. So I think it's a very thin speculation that he saw these messages. If a foundation is laid during trial that indicates that he did see them or he did know them, it would be different. But otherwise, these text messages are hearsay and they're not admissible for any purpose.
Let's hear what the judge says about that. But sure, I would think that that could be a strong catalyst for Brian Walsh, you know? If he found out, if he saw those text messages on New Year's Eve, they said that the conversations ended at around 10:30 p.m. on New Year's Eve between Anna and somebody called Will Fasto. And there's this alleged affair. And there's another friend who we saw a clip of at the beginning of the stream. If you missed the beginning of the stream, we did a full case recap, so check that out if you feel a little lost. There's also a huge playlist for you. Everything's on there. It's in the description box. I'll put in the pinned comment as well. But so this was December 31st of 2022. They had a friend over and they were celebrating New Year's. And then the friend called Jem left at around 1:30 a.m. And Anna's phone last pinged at her home at 3:14 a.m. on January 1st of 2023. So if Brian Walsh saw those text messages, knowing that he was already allegedly an abuser, yeah, you never know, hey?
How are they hearsay? In order, and what I'm focusing on is what in them, is to prove the truth of the matter asserted.
Well, then
I guess we'll have to look at each, and that's sort of where we're going to end up with the transcript, I suspect.
Well, then it kind of reverses the question back to the government. Why are they seeking to put this text message history in? They're putting it in because they want to wave it around and say she was having an affair and he knew and he killed her. That's what they want to do. And I think if there was actual evidence or proof, other than speculation, that he had seen these messages, was angry about them, we'd be in a different posture. But that is not the case.
Well, let's ask
him.
And so
why are they trying to put them in? And hearsay, her messages, her statements are hearsay. So what other purpose is it coming in for? I don't see a purpose other than to just wave this in front of the jury. Mr. Fastow is going to testify. He can certainly testify to the relationship between him and Anna, the duration, the time, but those text messages should not go in front of the jury.
All right. Kamal.
Please.
Your Honor, in addition to the defendant making statements about her iMessenger appearing on his phone, he also told the police that her phone was upstairs on New Year's Eve. He told police about some quarrel she had had with someone over text message and that had been put her phone upstairs in their bedroom.
Abdullah.
Yes. That's different than Mr. Mutlu's testimony that she was using her phone all night. So I suggest that's certainly...
Let me ask you this. Based on the forensic work done on the defendant's phone, is there any evidence that he was on his phone that night?
No, Your Honor, there's not.
Okay.
That's the phone that was
Missing.
misplaced.
Right. But you do have evidence, this has been the subject of other motions, that on the first and into the second, that there was some manipulation of that phone to unlock it. So I guess what I asked you, and it was a sort of a void in my mind of whether there was any evidence that he was on his phone on the 31st, and the answer to that is no.
The first time his phone was manipulated was at, I believe, 7:35.
In the morning of the 1st. All right, just trying to get the facts in my head.
And let's go over what he did at 7:35 a.m., shall we? Tell us about those Google searches again, because those are so bad. If you're feeling overwhelmed by the case, lost, confused, don't worry. As I say, there's a playlist, and even if you don't have time for that, I'll probably do another trial prep video for you, so don't worry about that either. But just watch the beginning of this stream later, because we did a full case recap there, okay? Lisa, welcome. Oh my. Used his phone at 7:35 in the morning, Started asking Uncle Google a few very, very dodgy things.
Well, more to follow on this as to individual text messages, and I want you to be focused on whether or not they are being offered for the truth of the matter asserted, and if they are, what your positions are, and see if you can make some headway on this.
Thank you, Your Honor.
Oh, Your Honor, the only other thing with respect to the messages, and this could be an email instead of, I just wanted to, we can certainly check, but if I could have the government verify if the messages they are proposing to introduce between Mr. Walsh and the other witnesses, if they have been edited at all, because we have like pages of text messages over a couple days to various witnesses, and I don't know if that is just the chunk that they are taking, or if they went in and cut out any messages.
Okay. And by the way,
I'll talk to the counsel afterwards.
Okay.
by the way, this motion that I'm talking about, we started to talk about Mr. Fasto and Anna Walsh's text messages. But to the extent that they're the defendant's text messages, which were the subject of this, then that's in a different bucket in terms of evidentiary ruling. Maybe not as important to you either, which is why you went to the other.
Right.
Okay. Commonwealth's number 15 is to admit internet history from devices in the defendant's residence.
Your Honor, the government has produced 2 binders that they expect to introduce into evidence. One is a binder of the gray MacBook, and then the other one is a binder of Oh, okay, we have 3 now.
All right.
So we appreciate that.
Are these for my own, sorry to interrupt you, but are these similar, if not the same, from what came into grand jury?
They're not the same to what came into grand jury.
Okay, because I'm familiar with those from the prior briefings.
This is significantly more material than what came into the grand jury.
Okay. Is it the same sort of format, though? There's a search and then the result of the search?
No, Your Honor. This would, I would suggest, be from a Celebrate report, and we have copies here that we can give to the court to review.
Okay.
But the Celebrate report for the MacBook pulls from 2 different databases, so you see the same search twice or the same visitation twice.
So let me ask you this. I have some questions that I need to process in my head.
Yes.
The searches that are done, is there forensic evidence that shows that the searches were done on the MacBook Pro?
Yes.
And not on the iPad?
Yes.
All right. That's what I suspected, but I haven't asked and nobody told me that. I assumed that that was the case.
Yes.
Because that was not the state of the evidence, as you know, at the time the case was indicted.
Yes, Your Honor.
So, and from that time, and that is March of 2023 when the case was indicted, are you saying that the forensic work has uncovered additional searches beyond what was known at that time?
Yes, Your Honor.
Okay,
my.
what's the volume of that?
Yeah, tell us.
So the MacBook report, that report that was generated is approximately 1,000 pages long.
Okay. Is that where this search, I hate to be so graphic, but well, it's not that, this isn't that graphic, but this, in paper number 201, I learned of a search that I had never seen before, which is
We're objecting to that one.
right.
Okay.
So that was not part of the grand jury.
It was not part of the grand jury.
What is the date of that search?
That is, I believe, forgive me because there's so many, but I believe it's in and around Christmas.
So
It's before
January 1st.
Yes.
Is it around the same time as the divorcing?
Yes, Your Honor.
Around the 27th?
If I may, I have a cheat sheet for myself.
Yeah, give us the cheat. We want the cheat sheet too.
It's 12/27, Your Honor. And it is approximately 8 hours before the searches for divorce.
So, Your Honor, there were more searches and hits in general on this topic, as you might see on someone's device. This particular search, the name was, I'm trying to be, it was also about having a threesome and impregnating someone. There's multiple searches for porn. He is an adult male. So I think to just cherry pick this one, and
I don't care about the
I think you should cherry pick it. Just include it anyway, okay?
porn part, so to speak. I mean, that is the, it's inflammatory, but it's the second part of that search, cheating wife. So that goes to the issue that we just talked about before, about his state of knowledge and what reasonable inferences can be drawn from that search being done on the 27th. That goes to that is an argument with regard to his state of knowledge on the 27th as to whether or not his wife was having an affair. Right? Exactly. I could care less about the porn part of it.
No, I understand. I think, but without getting into a semantical discussion about pornography, I think that there's millions of different interests, predilections of what people might watch or like, and I think that it wasn't just cheating wife. It was cheating wife has threesome and gets impregnated. So to say that could have been ancillary to what the content of the material was. So I think it's inflammatory. So when the court...
So there's this body of evidence of searches now that are not in my mind because they were, and it's not that it's inappropriate, that's why we have these hearings. But what would be helpful to me is if the Commonwealth, A, can provide me with those searches, and B, if you know, and it's not too much additional work, identify, and maybe it will become apparent to me because there's only the list of what you knew at the time of grand jury is pretty much encapsulated both in the grand jury transcripts but also in the affidavits.
Your Honor, we're prepared to give you the binders and a list of the items that we would seek to elicit at trial from the binders.
All right.
And we'd give that, of course, we've given the binders to counsel, but whatever we give to the court, we give to counsel.
And then if there are particularized searches that the defense is objecting to, I know you will raise them with me. And as a matter of logistics for how the jury is going to be presented this is even the stuff from grand jury, which I printed out because I'm still old school, is binders worth of materials that I have still with me. How are you going to present this to the jury?
So, Your Honor, we have, that would be tagged as an exhibit, a binder, but then it can be broadcast on these different monitors. So we can ask the witness about a certain entry in the report and put the entry on the screen and then have the witness testify from the screen saying this is what occurred in this entry according to the report.
All right. Just an awful lot of material for them to absorb.
We understand that. It's also important material to the Commonwealth's case. And so it's not an easy examination, but we do believe that it's important, and we've tried to make it as streamlined as we can.
All right.
Your Honor, too, just so the court is clear, I believe the government's position is that they're going to put in 3 or 4 actual binders into evidence, so the jury is going to get a giant binder of 1,000 pages. And so at what point does that become cumulative and prejudicial when they just drop by? And I'm just trying, is there a way to streamline this, or is there a way to cull some of it? Maybe that's something we can all work on. I just wanted the court to be aware that that is the intention.
More to follow.
More to follow.
All right. Paper number 16, to introduce Axios investigations hired by Diana Walsh, December 28th, 2022. Defendant is opposing. So what is it? Is the Commonwealth just seeking to admit through a person, presumably, that comes from Axios, because Diana Walsh is not on the witness list?
Yes, Your Honor.
So
We listed her as a witness, Your Honor. We don't know if we're going to call her, but we did list her in an abundance of caution.
all right, I'll make sure that she's,
I apologize, Your Honor.
I don't think she's on there.
It
She's
could
not
be a
on the list.
clerical error, but
Okay, so keep that so that,
She's also present in court right now, Your Honor.
Is that his mom? Prison in the
well,
courtroom?
do you want to do anything about that?
I didn't know she was on the witness list, so I didn't move to, I didn't move to sequester her for this hearing. So I didn't understand that she was going to testify, Your Honor. I apologize.
All right. So,
I can tell you what I would intend to introduce at trial from Axios. It's just very simple, a contract that was executed.
right, which I've seen.
Yes.
It's a grand jury exhibit.
Yes, Your Honor.
What's the objection to that?
So, Your Honor, what's the relevance of someone who the government isn't calling as a witness to introduce something that they did on the 27th of December?
Well, the relevance, and frankly, I'm going to ask that Ms. Walsh leave the courtroom.
Thank you, Your Honor.
I can speak more freely.
The judge is like, mm-hmm. I think it's his mother, yes.
Thank you.
Look at him. Bye, Mom.
So, Your Honor, the evidence that the government has provided us suggests that Diana Walsh contacted Axios Investigations on December 27th through email and phone calls, that she signed the contract, that she paid for it. In the grand jury testimony, Jeremy Dozier states that Diana Walsh specifically said, I don't want my son to know about this. So they're trying to basically say, she did this, we have no evidence that he was part of it, knew about it, directed it, paid for it, and it's just prejudicial and offensive.
I read somewhere, and it has to be in the grand jury, I read somewhere that the connection to the defendant is that she wanted to do this for some time because of the psychic, and that she went to the defendant or said to the defendant, I want to do this, and that he tried to rebuff her and say, no, I think his words were, Anna's a good girl, and, she's not having an affair, something to that effect. But then I also read somewhere, it has to be, again, in the grand jury, that he then gave her the name of Axios. So even though he said don't do it, he gave her the name of the company that she hired, right?
So if the government is going to elicit that information,
The only way that comes in is through Diana Walsh.
and they did not list her as a witness. So even if there was evidence that the government was planning to introduce that Mr. Walsh supplied the name, that doesn't indicate he paid for it, knew that she finally did it, was interested in the results. The evidence we do have is that the mother saw a psychic, and even the testimony, the evidence suggests that when Mr. Walsh was speaking to other people about it, he was dismissive of it, and even told his wife about it. So I don't think it's appropriate that they get to introduce the contract or the fact that Diana Walsh hired a private investigator on the 27th unless they're going to call a witness to link it to him and that he knew about it, wanted it, and was invested in the results. Otherwise, it's not relevant.
So, Your Honor, you were right about your memory of the grand jury testimony. That statement of the defendant giving the name Axios, that comes from his mother. So,
But you don't have her on the witness list, so how do you make that connection without her?
that's fair. We were suggesting it's a reasonable inference by the amount of contact the two of them had, and that he saw her frequently, and that he talked to her frequently over the phone. But again, we were trying to be very limited with what we were entering. It was just the contract through the private investigator. So with that, I think Ms. Porges, her assessment of the evidence is correct. And so I don't want to belabor this issue. That was the only thing we were trying to get. We were not trying to get any statements of the defendant, nor were we trying to get any statements of his mother, simply the contract.
Well, you make whatever strategic decisions you're going to make, but that may lead for a paucity of evidence on linking his knowledge to it. That's your choice.
Understood, Your Honor.
All right. Number 17 is paper number 203, and no objections to the calendar.
There isn't, Your Honor, but given the fact that my understanding is that there's going to be a blank calendar and items or notations may be placed on it, and I'm assuming then that is going to go to the jury.
Mm-hmm.
If that's the case, then the defendant would also like access to also add or denote things on that calendar. We can color code it, we can figure out a way, but that's what I would ask for. Or we can have two calendars, which seems superfluous if there's one.
We were just looking to give each juror an empty calendar so they could make their own notes and it would be part of their notebook, not something like that witnesses would be using.
So if they just want to give a blank calendar to the jurors so they can keep track of days, then that's fine.
Yeah.
Yeah, it just got confusing during the grand jury.
All right. 206 is allowed, sequestration of witnesses. 207 is a review. Commonwealth took no position.
Your Honor, may we be heard sidebar?
Yes.
Ooh, sidebar, okay. Brian Walsh went straight to Mama's house after the murder. And then today they said that there was some bloody rug found at Mama's house. Now we're learning that his mom also hired a private investigator to look into whether or not Anna was having an affair. And that would have been like 3 or 4 days before she was murdered. Interesting. I don't know why the state aren't calling her as a witness, right? Yeah, Mama of 3 said, I love that idea. Jurors can make their own timeline. I do like that they give them an empty calendar to fill in, you know, what's going on.
No objection.
Sure.
They're going to bring his mom back into the courtroom now.
So paper number 208, which is now moving to, did move at paper number 206 to the defense's motions limine. Paper number 208 is defense number 3. That is now mooted and requires no ruling. Paper number 209, defense 4. Commonwealth has indicated they will not seek such opinion, so no ruling is needed. Paper number 210, defense number 5. Commonwealth will not seek, no ruling is necessary.
Your Honor?
Mm-hmm.
Might we ask that a similar order regarding any awards or commendations for any defense experts that may be called? That they may not elicit that from those experts?
Well, to the extent that it goes to their qualifications, they need to do that. They need to know that the person's qualified, but no excessive lauding. How about we say that? On either side. Paper number 6 defense's motion in limine regarding any opinion that the defendant knew about the extramarital affair, and that was opposed by the Commonwealth at paper number 230. And as I understand the respective positions of the parties, is the Commonwealth's position is it's not seeking an opinion as to that, but is going to plant breadcrumbs such that a jury could, or could not, but they're hoping they could, infer the same.
We're zooming in now, camera
That's right,
person.
Judge.
Hey?
They told us they're not seeking an opinion, so that
Right.
answers it.
So that seems to be the line that the rules of evidence draw as well.
He does look just like his mother, hey? This camera, oh man, this camera is so focused on her right now. Did you did you see how they zoomed into her notes? I didn't see what it said, but I'm like, oh my. I'm actually kind of looking away. Oh my, this is awkward. You're really zooming in to her right now.
Paper number 7, defense number 7. What did I write here? Is paper number 212, and it's regarding opinion evidence, and the opposition was at 231. And I wrote to myself, what more do you want? And under what authority?
Well, all I'm trying to do, Judge, and all we're trying to do is keep these witnesses from taking the stand and start offering opinions as opposed to the facts of their investigation, that they not be asked opinions that they have not provided in all of these reports. Because when you read through the hundreds of pages, and what they've given us is all this search data and everything, that's fine. But they can't then elicit, do you have an opinion about what this means? They can't do that, and that's why we filed this motion. That's all.
I'll hear from the Commonwealth.
Thank you, Your Honor. Your Honor, we've provided voluminous discovery in this case. Certainly, we expect that the witnesses will testify as to what they did in conformance with their reports. They'll explain their reports to some extent, but the defendant has all this material that has all been provided. So we would, if there's something specific they're looking for, but again, the witnesses will not stray beyond the reports that have been provided.
All right, then we have no disagreement. As an aside, by the way, it is somewhat surprising to me as I was looking at this issue how little is said about experts in the context of, or how little is required by the rules in stark comparison to the civil rules. And I can't resolve that in my mind why the drafters of these rules sort of make a heavier burden on the parties in a civil case with regard to expert testimony than is expected in a criminal case. I don't know why. Curious.
If I may?
Yes.
I suspect it's because in criminal cases you have procedural due process bumping up against substantive due process, and that's not present.
Would you think that that would then err to the side of more disclosure for the defendant?
I think less, because fair trial strategy, and that might be different. That would be my thought.
My thought when I was sitting in the back is, why don't they have to produce what they have to produce in a civil case? But I don't write those rules. I just try to interpret them.
I don't want to belabor this point at all, but I remember Stephanie Page filing motions for depositions because you allowed depositions in civil cases.
Right.
And we were always shut down saying no, and we asked the same question the court's asking.
Well, I'm asking that question, and I almost never allow depositions in a civil case, even of the experts, but regardless, it's just a curiosity.
A lot of
Anyway,
tension in the courtroom.
Defense number 8, paper number 213, opposed at 232, and then another rebuttal at 281. To exclude defendant's request to consult with an attorney or statements of prior counsel. And I got more on that today, I think, too. Let's pause on that one. Bad Acts 214, paper number 9 for the defense. I think we've discussed this. It's opposed by the Commonwealth in a partial opposition of paper 233. And I had written to myself in my notes, question to the defendant specifically, what additional statements from the recorded interview does he want to exclude? But we're going to get to that in a minute. Paper number 215, defense number 10, motion in limine regarding witness characterization of evidence or of the defendant's behavior. The Commonwealth has said it will not seek character evidence, but will offer evidence of the defendant's behavior through observations. Is that right?
Yes, Your Honor.
All right, that seems reasonable and likely where the line is going to be drawn. Number 11, paper number 216, asking the Commonwealth to designate and provide notice of specific statements and internet searches contained in the digital data seized to be introduced at trial. Anyone wish to be heard more on that issue?
Your Honor, the Commonwealth did file a response in pleading paper 234.
I saw that. I will say that the Commonwealth's opposition at 234 seemed to take a reasonable approach, and likely where the line will be drawn. Is the pillowcase and the pillow, that's all over, right? There's nothing there.
We're not going to introduce it, Your Honor.
And there's nothing other happened with regard to the, this is just a hanging, dangling from the prior motions, the dinosaur, teddy bear, that's nothing I need to worry about.
Nothing you need to work on. We sent counsel a list of photos we were intending to introduce. I think that we cropped out any images like that, and so if there's any issues, they'll let us know.
All right. So how do we take on this, what the remaining issue that I really want to address today, and then I'm happy to talk to you about anything that you need to discuss with the court, is these transcripts. And I had about 5 minutes to look at the case that the Commonwealth has now cited in its most recent briefing of this morning, and I want to give it a closer look. But one way that we can approach this is to literally go line by line. I know that the defense has indicated, and I appreciate the way that this was laid out in the briefing, because it makes it very clear as to what it is that you're seeking and helpful. So I appreciate the work that you did to get that in that shape. And you've stated your objections. So one way I could do this is to just go through on this list that you gave to me and rule at some time between now and before the evidence is played, and give you a little bit more time to brief it. I will say that as I said to you at the side of the bench on Friday, but I think that there's a evidentiary issue that needs to be decided with regard to what the scope of the employment of Ms. Miner was. And I'm not sure how this new law fits within that analysis. If it does, if it's just a separate analysis, it almost seems like it's a separate thing completely, and a separate vehicle or avenue to admissibility, these adopted admissions. But I want to give the defense time to respond to that because it just came in this morning. And as to many of these statements, and so that you don't misunderstand where I thought I was on Friday, which was alerting you to the issue of agency, I'll call it. And I don't want either of the parties to be misguided by what I said to you on the side of the bench with regard to that. And what I mean by that is this. Even if Ms. Miner's Attorney Minor's statements aren't coming in, even if they weren't coming in. I never intended to not allow the Commonwealth to tell the jury that she was present there. So whether her statements come in is very different than whether her attendance at the interview was going to come in. And I think in the opposition that I saw, the papers that I saw flying, I think the Commonwealth, maybe based on what I said at the side of the bench on Friday, thought that I was excluding the latter as well, that is, her attendance at the interview. I also want to remind you of something that I said at the side of the bench on Friday, which is much of what Attorney Minor says is repeated by the defendant. And so the cumulative impact of those statements is not significant for the most part. There may be statements that she makes that are significant. It seems to me, and I'm sure the defendant is going to ask for the humane practices instruction. And if that is the case, it would seem to me that the dynamic of what is going on in that home during those interviews is relevant to that, specifically Thomas's role. I see you nodding your head no, but then I get to the later interviews. Maybe there's not enough in there for you to care about it. So why are you nodding your head no over there, Attorney Tipton?
I appreciate the time to respond. I was reading their cases at 4 a.m. That's not the best time to be reading cases. If the court...
I was blissfully ignorant of it at 4 a.m. I didn't see it until 7 a.m.
So if the court's... we will file a written response. My understanding is this court's going to give us time for that. And when's a good time to have that filed? You said you would make a ruling before the evidence started, so
right.
I'm just wondering.
I mean, honestly, the next couple of days we're going to be busy with picking a jury, and maybe even longer than that. So, I mean, I don't. As long as I rule on it, yeah. As long as I rule on it in time for you to make the appropriate edits, and I don't ruin, you know, the poor IT person that's going to be tasked with doing the edits. Thanksgiving. How deep into the case are these transcripts coming in?
Potentially the first day, Your Honor.
Well, great, thanks.
But the good news is, like you said, a lot of it was cumulative. And so in going over that, particularly the interview in the 7th, when we looked at it, we're like, there's really not a big problem with a lot of these. So we'll start working on some of those redactions. And we gave a list to the court of the things that we didn't object to. So we're going to start working on this.
So curiously, and I just want to make sure that this was a conscious decision on the defense's part and not something that was unconscious. There's some of what she said that you kept in. You know that. Well, attorney.
No,
there are some statements that you did not ask to be, and so.
From Tracy Minor, Judge?
Yes.
Well, then that was an error. That's the highlight didn't carry through.
Okay. All right.
Because, and I don't want to interrupt the Commonwealth. And we're going to file a written response. Let me just lay the groundwork for it, though.
Sure.
The court brought up the humane practice. We footnoted in a pleading. We never asserted humane practice. We're not asking for humane practice. Okay?
All right.
That is the bottom line here. And the Commonwealth's citation to sheriff in their latest briefing, they misstate what the law is. The law is if humane practice is a live issue, the court is required by law to give it humane practice. It's not a live issue. We've never raised it. So I want to set that groundwork.
All right. I appreciate that.
2, I understand what the court just said about you never intended to indicate you were going to exclude the presence of Tracy Minor. Our prejudice, contrary to what the Commonwealth argued in their brief, in their memo they filed last night, we made it very clear what the prejudice is. The prejudice is from the fact that Tracy Minor is there and all these statements are being made. Not the statements necessarily of Tracy Minor, but the statements of the client. And we made clear what we think the prejudice is. And that prejudice, once again, we'll lay it out in more detail. But that prejudice is the same type of prejudice that flows from the Commonwealth's reaction to Proctor. And I won't go into anything about Proctor except for the fact that once Proctor's integrity was impeached, the Commonwealth moved away from him. Why? Because his impeached integrity reflected on this office, the Norfolk County District Attorney's Office. Our prejudice is that what happened at these interviews, that Tracy Minor was there, that the jury can take that to say, as we said, either he's lying to his attorney, therefore he's lying to us, and they can't believe our representations during the trial, or his attorney was complicit in the misrepresentations he was making to the police because she chimed in, but she was there, and so now we're making misrepresentation on his behalf. That's the type of prejudice we're trying to avoid. And finally, we're going to be arguing, why is it relevant, especially when you take the humane practice out of it? There is no relevance to Tracy Minor being there. So we'll brief it, but I wanted to lay the groundwork for that.
All right. So I appreciate that preview. And I appreciate the reminder with regard to the humane practices, both for myself and also to the Commonwealth, as we move forward and try to resolve this issue for you.
And could I just make one more suggestion? If the Commonwealth could take the highlighted sections that we provided to the Commonwealth and you.
Yes.
And just now, go take those highlighted and maybe color code all of these statements they've listed. Wouldn't it make it easier for us all?
Well, I think we can get down to I think if you get rid of the cumulative stuff, you're really probably down to not a lot.
Right.
So that might be a good idea. What do you think about that?
I think you're right, Your Honor. I think that the issue became with the transcripts. Once you started taking her out, it became confusing. So she would actually ask a question, and he would answer it.
Right.
Or she would correct him on the restitution figure 3 times in a row. So then he's just shouting numbers out, and it doesn't make sense. So a lot of it was just confusing with what was being proposed. So we're trying to go back and be more strategic about this.
All right. And so my goal is to make things clearer and easier for the jury
Yes.
than confuse them. And so to the extent that that you're having that situation where there's a question that she's asking that he's answering, and it's cumulative, the relative prejudice, I understand the argument, and I'm not ruling on it right now, Attorney Tipton, because once she's there for one answer, she's there, your argument is going to be the prejudice attaches. I understand the argument. But it's also incumbent upon me to provide evidence to the jury that they can, in a manner that they can consume it. And if it's doing so, once I balance the prejudice in a way that allows them to digest the evidence, but I'll think more about the prejudicial issue. And maybe you can get, there really is not a lot that she says that he doesn't repeat. So, how about Friday?
Sorry, I'm just going to pause. Aaron says, was Proctor involved in this case? Lots of people are talking about it as well from, the other trial in Massachusetts that happened. And yes, he was apparently involved in this case, and I'm sure the defense is going to bring it up a lot. Okay, so let's see what else I'm going to say.
Color coding.
Yes, Your Honor.
All right. That's all the motions eliminate, right?
Yes, Your Honor.
All right. So, not much else that I have other than the jurors that were called in today. were being used for a civil case. They're going to be told at the end of the day that they're being held over till tomorrow, and that's so that we will get a big yield tomorrow, and hopefully both, I'm hoping to take 70 of the jurors tomorrow, and the remainder will go hopefully to Crim 2 so that they can get their work done too. And then every day they're going to be held over, so we will have jurors right through till Friday, because as you know, typically we don't get jurors on Friday. And we'll seek to 16. Any questions that you have lingering that you need answered between now and tomorrow morning on anything?
No, but I would ask to come to sidebar on an unrelated matter to this case.
Okay.
When it's on.
Anything the Commonwealth needs?
No, Your Honor. I think that we'll work together and try and figure out some of the other issues we've talked about today. I've been keeping a running list and just trying to make sure that we stay on schedule.
All right. I will see you at the side of the bench.
A little sidebar. Jen says, your makeup is always flawless. Is that so? Thank you so much. Oh, Brian Walsh, okay. Jury selection starts tomorrow, everyone. November 18th of 2025. And they're anticipating opening statements for December 1st of 2025. The judge said after the Thanksgiving weekend. Okay. So they might already have their jury picked, let's say, you know, by Thursday or something. But then they'll start around, on or about December 1st. Everybody see what day that is? Yeah, okay, oh, so we've got this week. Oh no, that's still a while. Wait, this week? They got a while to pick the jury. Interesting. We'll see when they're done. Okay, now we can't see anything. Let's go forward. There he is. Really, dude? You're going to take this to trial? Hey, I know that they have not found Anna's body, but my goodness, there's a lot of evidence against him. Okay, now we're all caught up. Wow, this is awkward. Just staring at him. Thank you, camera person. What we got there? Ooh, there's the mom. Brian Walsh's mother. Charlotte said yes, he's definitely guilty. Oh my word, I don't think we should be looking at... No wonder the judge wants to use Zoom. Otherwise, you know, we can zoom into her notes. People in the courtroom. I don't think the judge will like that. We shouldn't have said this is awkward and we're staring at Brian Walsh, because this is more awkward, staring at his mother. Rather the defendant, right? Rather the defendant. Let's snark at him. Thank you all for being here to watch this pre-trial hearing with me. I was just so curious, you know. What's going to happen here? What are they deciding? I was just also waiting to see, oh no, are there going to be more delays? I thought there could be. I hope there won't be. Crystal Ann said, I can't believe how confident he is. I think he's quite delusionally confident, right? Yeah, Jen said, that's his mom. She looks fantastic. That's his mom. Karen's Camp said, is his mommy's name Donna? I think it's Diana, is what they said. Cord Lurker said, this camera person is naughty. I don't think they're too naughty, but I don't think the judge will like zooming into the mother's notes. Melissa says, Melissa loves true crime. Been delayed long enough? I know, right? We've been covering the case for a while. It's been a while to get here. I mean, the crime happened, I know about, January 1st of 2023. So here we are now in November of 2025. Yeah, no, we could just stare at him a little bit. Oh dear. Robin, I hope not. Maybe he thinks he's got a chance. But how will they know? Oh, they're gonna know. I can hear things too. There's beeping going on. So no, sarcasm, you're not the only one. We can all hear it. Deb says, has he been in jail or walking free? He's actually been in jail, being held on no bail this whole time. If you missed the beginning of the stream, I hope you'll check it out. We did a full presentation, an overview of the case. We looked at all of this. Right, when they met, what happened that we know of and all of that. And that Brian Walshe was arrested on January 8th of 2023 for misleading investigators. That's what he was arrested for initially. And then on January 18th, he was charged with first-degree murder, misleading a police investigation, and improper conveyance of a human body. So Arno's body's never been recovered, making this a no-body murder case. And then there's those Google searches of his. We've gone over that. We went over the physical evidence they've got as well. All of this. He's facing first-degree murder charges, mandatory life without parole if convicted, misleading a police investigation, and improper conveyance of a human body. He's pleaded not guilty to all the charges, and he remains in custody without bail. On September 11th of 2025, he was stabbed at the Norfolk County Sheriff's Correctional Center. And following this incident, he was sent to Bridgewater State Hospital in Bridgewater, Massachusetts for his mental competency evaluation, where he stayed for 40 days, and he's back in the jail now. Jury selection starts on November 18th of 2025, with opening statements anticipated for December 1st of 2025. Yeah, the beeping sound is from the court feed, so from my side. Maurice Australia said, gee, thank you for all your amazing work and dedication. It's been a pleasure to be a Grizzly. I admire your care and love of all the victims. Thank you for being a member for 36 months. Kathleen said the sound is the white noise machine because of the sidebar. So we can probably expect to hear more of that during the trial. Lamisa said, was he moved after the stabbing? I don't think so. I think he just went for his mental competency evaluation, stayed there for 40 days, and now he's back in the same jail. I think, from what I've researched. Let me know if you know different. Wendy says, are his parents together? Maybe dad won't participate. I don't know, but from what I remember, I don't think so. Remember, his dad disowned him in 2018. What did they call it? Disinherited him. Is that what it was? Brian has a notable family background. His father, Dr. Thomas Walshe, was a prominent neurologist who disinherited, there we go, Brian in 2018, citing his son's lack of common sense and propriety. And then Brian was very mad at that. I want to be part of the inheritance. And then he sued, but he lost. And then on April 1st of 2021, he pleaded guilty in federal court to defrauding art buyers involving forged Warhol Shadows paintings sold for over $80,000. Okay. Yella is laughing at the dad's reasoning. Yeah, he's not gonna. The dad's like, he's getting none of my inheritance. Court looker said there was a man who walked in and the mom could also be her attorney, for all we know. We don't know who the man is. Could be a friend, could be an attorney, could be a boyfriend, it could be a stepdad. We don't know. Yep. Kathleen said the viewers are going to pay the price for the zooming in. We've seen it before. Yeah, unfortunately. And I think that's why the judge is like, oh, okay, we'll do it with the court zoom only. Which, of course, it's not as great a view or a viewing experience, should I say, when it's on Zoom compared to this, like having cameras in the courtroom, right? So that kind of sucks. But anyway, we'll see what it looks like. A couple says, BW is a crook. Yeah, he's a con man. He's a crook. Let me do this. Wait. Well, when I do that, they're probably coming back, aren't they? Yep, the minute I want to show you something, they're back. Might as well say works every time. Let me quickly show you. Oh no, yeah, they are. They're back.
So the plan is we'll see each other. We'll end today's work. I appreciate the commitment to do some further work on issues, but I think we're really in pretty good shape as we move forward to the start of this. I will get you later this afternoon the what I believe is the most updated witness list, which will be attached to that supplemental questionnaire. Take a look at it carefully, and I made some changes, some other minor changes that you'll see in there.
And I think we'll be able to give the court the binders of the internet stuff with spreadsheets of the isolated ones that we're looking at.
All right. That sounds good.
Thank you, Ron.
Have a good day, and we'll see you back here at 9 o'clock tomorrow morning.
Excellent.
That is continued to November 18th at 9 a.m. Thanks, everyone.
Buckle up, Brian Walshe. Your ass is going to trial. When you want to take it to trial. Could just plead guilty if you wanted to. But anyway, plead not guilty, and let's see this.
No? Okay. I like to keep it simple now.
Okay. he has public defenders, but they seem to be very strong attorneys, hey? Very strong public defenders. I think it'll be an interesting trial to watch.
Hey, Guy, I know Soraya mentioned to you taking down your stuff for the court reporter. Court reporter's not going to be here till Thursday, so we'll need you to release tomorrow and Wednesday. All right.
No.
Thank you.
Hold on one second. I want to tell you something. I just want to see what's going on here quickly. Yeah, that. Thank you, Zenjan. I was hoping you're going to say it again. You said, I'm pretty sure Brian's dad is no longer alive. That's how we know about the disinheritance, because he sued to get it. Right? See, I have to watch my own playlist too. I have refreshed my recollection with the documents today, but I got to watch that, those little details, because I think that's all we have, right? Because when I asked Uncle Google now, he says, Brian Walshe's father, Dr. Thomas Walsh, died in September of 2018 while on a trip to India. Oh, okay. Yeah, and then he tried to get the inheritance. He sued over it because his dad had disinherited him and gave that reason. Okay. Now we're just lurking. We're looking what's going on in this courtroom, hey? I don't think much, is still going to happen. So let me quickly show you this. Okay, wait, let's go like this. And I want to show you this quickly. These are the... Hold on. Go here. Okay. Those are the fake paintings, the fake Andy Warhol shadow paintings that he had been conning people with. Brian Walsh sentenced for scheme to sell counterfeit Warhol paintings. So that is what he did. Also, let me quickly show you this. This, everybody's the playlist, okay? So we started over here 2 years ago. Missing Anna Walsh's husband arrested for misleading police. And then, update, Anna Walsh's husband, Brian, charged with murder. So that happened within 2 weeks or so. Brian Walsh in court facing murder charges. That was the live arraignment. Anna Walsh, $2.7 million life insurance. See, I got to refresh my memory on that one. Life insurance, is that so? See, we were just wondering that again today. So here's the homework that I will be part of too. You want to do homework with me? I think I might make another trial prep video for you as well. And then here's the final pretrial hearing. So they're hoping for opening statements on December 1st, as we know. I just had one more clip to show you, which is where? Wait. Yeah, this one. Let's quickly look at this one.
Now left the family's home after spending days here, and new clues continue to emerge tonight in this mysterious case. Video of Brian Walsh at a Norwell juice bar the day after police say his wife Anna was last seen. Investigators say he told them about the stop, but misled them about other travels, including a $450 cash purchase of cleaning supplies at Home Depot.
You can't think that someone is misleading you unless you have a sense of what the truth really is.
Investigators could be getting closer to the truth. 5 Investigates has learned that the search of a trash facility on the North Shore near his mother's home uncovered a rug with blood on it, along with a hacksaw similar to this. They also say a knife and blood were found in the basement of the family's Cohasset home.
If you imagine like a big jigsaw puzzle, there's lots of different pieces that have to get put into place before you can step back and see the photo and the picture that gets created.
News Center 5 legal analyst Vince DeMoore says gathering evidence can be painstaking. Right now, Walsh is only charged with misleading investigators.
At that
when you
time,
see that smile, you go,
look at him, look at him.
I didn't really know Brian the way I thought I.
We looked at that. Remember how he was like, oh yeah, charged with misleading the police. He didn't even think that he would get charged with murder. And this was on, I think it was January 8th, and by January 18th of 2023, he was charged with murder. Tickety Boo says, love this channel. Thank you so much for your membership. And also Bridget J, thanks for 10 months of support. You said definitely doing homework. Nice.
The evolution of the case has troubled friends like Rick Weber, who's known the family for years.
Did I miss something? Were there signals? Did any of Brian's behavior strike me in any way as off key? Nothing.
Investigators have also visited a trash facility near the Cape as they continue to look for clues. But as the days go by, friends of the couple are growing discouraged and disillusioned as they learn more details.
This guy could have run for Congress, and you would vote for him. That's how nice and charismatic he was.
Now, investigators say that any items recovered at that trash facility up on the North Shore will now be tested to see if they are connected to this case. We're live in
And we would like to know about that from the trial, right? They're probably going to tell us about all of that, all the testing and things that went on there. So Deb said opening statements not till December 1st, but jury being picked now. Why? Because of the Thanksgiving holiday in between. The judge wants to make sure that once they start the trial, that they're going for it in a streamlined fashion with no long weekends or long breaks in between, right? Okay, well, thank you so much, everyone, for watching that with me today. I hope you'll check out the playlist, check out some of the previous episodes we did. I'm sure there's information that we all going to find there that we need to refresh our recollection with. And yeah, I look forward to seeing you again very soon. Look out probably tomorrow, latest the next day, for an interview that I did with Detective Schroeder, who was the digital forensics expert, the Celebrite guy, the one that found Uncle Google searches, in the Matthew Paul trial. So I had the opportunity to interview him as well as the canine handler. The canine handler interview is already out. This one, I'm still working on editing and all of that, so that'll be out hopefully to premiere for you tomorrow. If you ever wonder where I am, I'm usually on YouTube every day, right? Live stream, videos, premieres, shorts, whatever it is. So always check the channel because YouTube might not notify you so well and you might be unsubscribed, automatically. So make sure you are subscribed with the notification bell on. And then I will see you for that premiere as well. Okay, looking forward to that. I'm going to be working hard on that now. And yeah, we will do some more trial prep for Brian Walshe's case so we all feel ready to snark at him once his trial starts, right? Okay, thanks everyone. Have a great evening further, whatever time it is for you. Thank you, mods.